Peace, administrative harm, public law, and the unrecognized casualties of state power. This article introduces the concept of the victim of peace as a category of public law analysis. It asks whether modern administrative law has adequate conceptual, procedural, and remedial tools for individuals whose lives are severely damaged by peacetime state action without the dramatic visibility of physical violence, financial fraud, or wartime injury. Public law is well equipped to speak about legality, VIRs, procedural fairness, irrationality, proportionality, and the formal review of decisions. It is less well equipped to speak about administrative destruction, the cumulative harm produced when state institutions operationalize unverified risk narratives, internal markers, security proxies, informal warnings, or opaque system flags against a person who is then denied the procedural status necessary to challenge the harm effectively. The article does not seek to answer this problem conclusively. Instead, it identifies a research agenda. It argues that the victim of peace exposes at least 5 structural questions: the mismatch between operational targeting and procedural standing, the absence of a general compensatory remedy for serious administrative illegality, the taxpayer paradox of suing the state, the accountability gap created by institutional rather than personal liability, and the potential role of artificial intelligence in diagnosing systemic administrative defects before they become life-damaging events. The article asks whether public law should move from a narrow model of decision review toward a richer model of harm recognition, justification, repair, and institutional learning. Keywords: public law, judicial review, administrative harm, state liability, victims, artificial intelligence, accountability, procedural fairness, reasons, administrative justice. Modern liberal democracies possess a developed moral and legal vocabulary for the victim of war. In periods of geopolitical tension, the language of civilization frequently organizes itself around the duty to support those harmed by aggression, occupation, forced displacement, war crimes, and gross violations of human rights. International law recognizes the right of victims of gross violations of international human rights law and serious violations of international humanitarian law to equal access to justice and to adequate, effective, and prompt reparation. The United Nations Basic Principles and Guidelines on the Right to a Remedy and Reparation are one prominent expression of this architecture. This vocabulary is essential, it should not be weakened, but its existence reveals a contrasting absence. The person whose body is attacked is recognizable as a victim of violence. The person whose money is stolen is recognizable as a victim of fraud. The person whose home is destroyed in war is recognizable as a victim of armed conflict. Yet the person whose life is damaged by peacetime administrative power often occupies a much more ambiguous position. She may not have been physically assaulted. She may not have lost money in a simple transactional sense. She may not have been displaced by bombs or military invasion. Instead, her life may have been damaged by a state institution acting through a combination of internal notes, security labels, unverified suspicions, system flags, police escalation, professional exclusion, refusal to explain, and later procedural denial. This article proposes the term victim of peace for this neglected figure. The term is deliberately paradoxical. It describes a person harmed not by war, but by the ordinary machinery of a peaceful state. The injury is not inflicted by an enemy force, but by the institutions that claim legality, order, security, and rational administration as their own normative foundations. The harm does not necessarily arrive as a dramatic act. It may arrive as a marker in a database, a hostile instruction to security personnel, a refusal to grant access, a classification that cannot be seen, a reason that is never given, a complaint routed into the wrong procedural channel, or a litigation position that denies the claimant standing while preserving the practical consequences of treating her as a risk. The central question is not whether public authorities must be able to protect security. They must. The question is whether public law has sufficient tools to deal with the moment when security becomes an administrative language through which unverified assumptions are operationalized against a person without evidence, reasons, proportionality, review, or repair. The question is especially acute where the state treats the individual as sufficiently real to restrict, flag, exclude, investigate, or escalate, but insufficiently real to receive an explanation, a hearing, an effective remedy, or compensation. The victim of peace is therefore not merely a rhetorical device. It is an analytical category. It points toward a structural gap between harm and remedy, between operational power and legal accountability, and between the state's capacity to damage life and public law's capacity to recognize life as the object of that damage. Traditional legal categories often identify harm through more visible objects: body, property, money, liberty, reputation, privacy, or contractual expectation. Criminal law knows how to name injury to the body. Private law knows how to name loss to property or money. Human rights law knows how to name violations of protected rights, although only where the claimant falls within the applicable doctrinal frame. Public law knows how to review the legality of state decisions. But the victim of peace problem arises where the primary object damaged is more diffuse, life as a functional whole. The injury is not reducible to one moment. It may consist of reputational contamination, status degradation, professional obstruction, exclusion from ordinary spaces, chronic uncertainty, stress, loss of time, loss of opportunity, and the forced diversion of intellectual and financial resources into resisting the administrative machine. The person is not merely deprived of one benefit. She is required to live inside an imposed administrative reality. Suspected but not charged, restricted but not heard, affected but told that no decision exists, harmed but told that no compensatory wrong has been committed. This produces a distinctive form of legal exhaustion. The claimant must become the investigator of her own harm. She must reconstruct the chain of causation from fragments, emails, notes, access records, police comments, internal references, complaint responses, procedural refusals, and litigation pleadings. She must prove that the harm exists before she can even argue that the harm was unlawful. In physical or financial harm cases, the injured object is often visible at the beginning. In administrative harm cases, visibility itself is part of the struggle. This suggests a first research question. Should public law recognize life disruption or administrative life damage as a distinct object of analysis, even where the harm does not fit neatly into existing private law torts, convention rights, or financial loss categories? The first doctrinal gap concerns standing. In ordinary judicial review, the Senior Courts Act 1981 requires the claimant to have a sufficient interest in the matter to which the application relates. By contrast, Section 7 of the Human Rights Act 1998 requires a person bringing proceedings against a public authority to be, or to be at risk of being, a victim of the unlawful act. The distinction between the flexible public law concept of sufficient interest and the narrower HRA victim model is well recognized in commentary on standing. The victim of peace problem does not arise simply because standing rules exist. It arises because the state may adopt inconsistent positions about the claimant's status. Operationally, the claimant is treated as a distinct object of concern. She may be flagged, excluded, restricted, escalated to security personnel, or treated as a risk. Procedurally, however, the same claimant may be described as derivative, parasitic, incidental, or lacking independent standing. The state says, in effect, you are sufficiently independent to be targeted, but not sufficiently independent to challenge the targeting. This asymmetry should be treated as a major public law problem. It allows the state to convert a person into an operational object while denying her procedural personhood. The claimant becomes a security subject for the purpose of restriction, but an administrative non-person for the purpose of reasons, hearing, review, or remedy. The research questions are therefore precise. Where the state imposes a claimant-specific operational consequence, should standing follow the consequence rather than the formal status label? Can public law tolerate a distinction between derivative status on paper and independent targeting in practice? Should the existence of a claimant-specific operational measure create a rebuttable presumption of sufficient interest, even if the claimant lacks a formal entitlement to the underlying benefit, access, or status? Public law is traditionally structured around the review of decisions, acts, failures to act, policies, and exercises of public power. Yet modern administrative harm often occurs through what might be called effect without decision. The claimant experiences the consequence, but the institution denies the existence of a reviewable decision. The restriction is described as an internal note, a system entry, an operational matter, a security instruction, a local practice, a context, or a downstream consequence of someone else's decision. This is not a merely technical problem. It creates a constitutional problem. If public power can be exercised through non-decisional mechanisms that produce real-world effects, then the traditional decision-centered model of judicial review becomes vulnerable to evasion. A person can be controlled without being formally decided upon. She can be excluded without a refusal letter. She can be treated as a risk without an assessment. She can be escalated to enforcement without a recorded legal basis. The House of Lords' reasoning in Unrecognised remains important because it rejects the idea that an uncommunicated administrative decision can bind an individual. Lord Steyn described the proposition as astonishingly unjust, and observed that surprise is regarded as the enemy of justice. Although Unrecognised concerned benefit entitlement and notification, its deeper principle speaks to a wider pathology. A person cannot meaningfully challenge administrative power if the operative basis of that power is concealed. The research question is therefore, should public law move from a decision-centered model to an effect-centered model where claimant-specific administrative consequences are produced through internal systems, markers, or operational instructions? A further question follows. Should a claimant-specific operational effect itself trigger duties of notification, reasons, review, and correction, regardless of whether the public authority chooses to label it as a decision? The second structural gap concerns remedies. Judicial review is designed primarily to control legality, not to compensate injury. Section 31 of the Senior Courts Act 1981 allows damages in judicial review only where such damages would have been available if the matter had been brought as an ordinary action. The result is a familiar remedial gap. A claimant may establish that a public body acted unlawfully, irrationally, unfairly, or for an improper purpose, but still receive no compensation unless she can establish an independent private law cause of action, a statutory damages route, or a breach of a convention, right capable of producing damages. The Law Commission's project on administrative redress recognized the difficulty of this terrain. Its 2010 report reviewed the relationship between public law wrongs and monetary remedies, but the state liability reform proposals were not taken forward in the form originally contemplated. The current position therefore continues to produce hard cases. Serious administrative fault may cause substantial life damage without generating a direct compensatory remedy. For the victim of peace, this is not merely doctrinally untidy, it is morally and constitutionally significant. If a state institution damages a person's life through opaque, defective, or unjustified administrative action, the absence of compensation does more than deny money. It denies recognition. The law says, the act may have been unlawful, but the damage to your life is not itself compensable through public law. This leads to a third set of research questions. Should serious claimant-specific administrative illegality give rise to a limited compensatory remedy even in the absence of a traditional private law tort? If not, how should public law recognize and repair administrative life damage? Is the current division between legality remedies and compensation remedies defensible in cases where the state's unlawful conduct causes severe reputational, professional, psychological, or relational harm? The victim of peace also exposes a paradox of public compensation. When a citizen sues a private wrongdoer and wins damages, the wrongdoer pays. When a citizen sues the state and wins damages, the compensation is paid from public funds. The claimant, as a member of the tax-paying public, has in a conceptual sense helped finance the institution that harmed her, the lawyers who resisted her claim, and the compensation that may eventually be paid to her. This paradox should not be overstated. Taxation is collective, not individual hypothecation. A claimant does not literally pay her own damages check. But the deeper point remains, the state litigates with resources extracted from the public, including from those it harms. The individual claimant bears personal stress, personal costs risk, personal time loss, and personal reputational exposure. The defendant institution bears those burdens institutionally. Its officials rarely experience the litigation as a personal financial event. This creates a structural asymmetry that ordinary costs rules do not fully address. Even where the claimant wins, she may have spent years financing her own resistance to the machine. Even where damages are awarded, the institution may treat payment as a budgetary event, rather than a moral, organizational, or disciplinary failure. Even where a court finds unlawfulness, the state may absorb the judgment without changing the underlying administrative culture. The research questions are uncomfortable but necessary. Can compensation alone be an adequate remedy where the claimant has effectively been forced to fund, through taxation and personal expenditure, both sides of the conflict? Should serious administrative illegality trigger not only compensation, but mandatory institutional learning, audit, apology, correction of records, and individual accountability review? Should public law remedies be designed not merely to pay the claimant, but to prevent the state from treating unlawful harm as a cost of doing business? A further difficulty concerns personal liability. Public administration is often defended through institutional shields. A decision is made by a department, command, office, agency, or public authority. Litigation is conducted by government lawyers acting in an institutional capacity. Internal reviewers apply statutory limits. Complaints handlers describe themselves as unable to examine the underlying issue. Each actor may have performed a small part. The result is severe harm, but responsibility is diffused. English law does contain personal liability mechanisms in specific circumstances. Misfeasance in public office, false imprisonment, negligence, professional discipline, wasted costs, contempt, and criminal misconduct are not non-existent. But these routes are exceptional, fragmented, and often ill-suited to ordinary administrative wrongdoing. The more typical experience is that the institution is sued, the public purse funds the defense, and individual officials remain outside the structure of meaningful accountability unless their conduct crosses a high threshold. The victim of peace problem is therefore not only about the claimant, it is about the disappearance of the responsible legal subject within the state. The claimant is individualized. She must bring her claim, meet deadlines, pay fees, face costs risk, and produce evidence. The state is collectivized, responsibility is distributed across offices, systems, records, delegated decisions, and litigation teams. The research questions are: should public law develop a more refined doctrine of administrative responsibility mapping, where a claimant's specific harm is produced by a chain of officials? Should courts or tribunals be able to require identification of the decision-maker, transmitter, reviewer, and defender of the contested measure? Should repeated or serious administrative illegality trigger personal accountability assessment, even if not necessarily personal financial liability? Can a democratic state remain accountable if the individual harmed by state action is always visible, but the individuals who produce the harm remain procedurally invisible? Public law often assumes an articulable decision architecture. The legality of state action is assessed by asking familiar questions. Was there lawful power? Was it exercised for a proper purpose? Were relevant considerations taken into account? Were irrelevant considerations excluded? Was the decision rational? Was the procedure fair? Was the measure proportionate, where proportionality applies? These questions remain indispensable, but they may also assume more rationality than institutions actually possess. Modern administrative harm may not arise from a single official weighing evidence and choosing a course of action. It may arise from social contagion, bureaucratic deference, unverified security narratives, risk aversion, prejudice disguised as caution, or blind obedience to system flags. A note becomes a fact. A suspicion becomes a marker becomes an instruction becomes police escalation. Police escalation becomes later proof that there must have been a concern. The system manufactures its own justification. This phenomenon is especially dangerous in security contexts. The language of security carries institutional gravity. Once a person is associated with risk, the burden silently shifts. The claimant must disprove an unstated concern. The state can rely on opacity. The absence of evidence becomes difficult to challenge because the claimant is not told what evidence is said to exist. The research questions are: how should public law respond when the apparent reason for state action is not a reasoned assessment, but an institutional contagion effect? Can doctrines of rationality and relevant considerations adequately capture administrative harm generated by informal narrative transmission and system-level repetition? Should courts require public authorities to produce an articulable decision architecture for any claimant-specific measure that materially damages status, access, liberty, reputation, or livelihood? The victim of peace problem also raises questions about the intensity of review. Traditional Wensbury unreasonableness may be too blunt for serious claimant-specific administrative restrictions that do not fall neatly within the Human Rights Act or other proportionality-based frameworks. The Supreme Court has repeatedly engaged with the relationship between common law review and proportionality, including in Kennedy, Pham, and KU, though English law has not adopted a universal freestanding proportionality test for all ordinary administrative law cases. The question is not whether judges should become administrators. The question is whether severe operational restrictions imposed on a specific person should require a structured justification. If the state restricts a person on a security basis, should it be enough to say that the measure was within a broad range of reasonable responses? Or should the state have to show a legitimate aim, a conduct-based factual foundation, rational connection, necessity, and fair balance? This is particularly important where immutable or crude proxies are involved. Place of birth, nationality, family association, personal relationship, language, ethnicity, or perceived political context may be administratively tempting because they are easy to record, but ease of recording does not make them lawful risk assessments. A proxy is not a fact-specific evaluation. A marker is not a proportionality analysis. A label is not evidence. The research questions are, should severe claimant-specific operational restrictions trigger structured proportionality review, even outside classic human rights contexts? Should public law treat immutable or origin-based proxies as presumptively suspect unless supported by claimant-specific conduct, evidence, and necessity? Does the distinction between irrationality and proportionality remain defensible where the state's action damages a person's life while avoiding the formal categories that trigger heightened review? Artificial intelligence enters this discussion in two contradictory ways. On the one hand, AI can intensify the victim of peace problem. Algorithmic or semi-automated systems can multiply opaque classifications, embed biased proxies, and produce administrative effects that no individual official fully understands. On the other hand, AI could become a tool for diagnosing defects in state machinery, tracing causal chains, identifying repeated patterns of administrative failure, mapping responsibility, detecting contradictory reasons, and distinguishing contemporaneous reasoning from retrospective rationalization. Current AI governance frameworks already emphasize transparency, explainability, fairness, accountability, contestability, and redress. The OECD AI principles promote trustworthy AI that respects human rights and democratic values, including transparency and accountability. The Council of Europe's Framework Convention on Artificial Intelligence seeks to ensure consistency between AI systems and human rights, democracy, and the rule of law. UK public sector guidance similarly identifies principles including safety, transparency, fairness, accountability, and contestability. For administrative justice, however, the more interesting question is not simply how to regulate AI used by the state. It is whether AI can be used to audit the state itself. Could AI tools analyze complaint histories, litigation outcomes, internal decision patterns, and data markers to identify departments or actors repeatedly producing unlawful harm? Could they measure the distance between contemporaneous records and later litigation positions? Could they identify when a security concern has no recorded factual basis? Could they map who created, transmitted, operationalized, reviewed, and defended a harmful administrative narrative? This must be approached carefully. AI should not become a new, unaccountable judge of public servants or citizens. It should not replace legal judgment. It should not produce personal liability through automated scoring, but it may assist in creating what public law currently lacks, a systematic diagnostic layer capable of seeing institutional defects that individual litigation reveals only fragment by fragment. The National Audit Office has already considered how government is preparing to use AI in public services and how risks are to be mitigated. Accountability and ownership remain central issues in public sector AI adoption. The research questions are, can AI be used as an administrative defect detection tool rather than merely as a service delivery tool? Could AI-assisted audit identify patterns of unlawful administrative harm across departments, complaints, litigation, and internal records? Can AI help allocate responsibility within complex institutional chains without replacing human judgment or due process? Should future public law remedies include mandatory data-based institutional learning, where unlawful harm reveals systemic administrative defects? The final and most difficult question concerns personal liability. The instinctive argument for personal liability is clear. If state officials, public lawyers, or institutional decision-makers can harm individuals without personal consequence, the system may lack adequate deterrence. If the only consequence of unlawful action is that the public body pays from public funds, the individuals who created, defended, or concealed the harm may have little incentive to change. But personal liability carries risks. Public administration requires judgment under uncertainty. Excessive personal exposure could produce defensive bureaucracy, risk aversion, recruitment problems, and reluctance to make difficult decisions. The question is therefore not whether every administrative error should generate personal liability. It plainly should not. The question is whether the law needs an intermediate accountability category between ordinary institutional liability and exceptional tortious or disciplinary misconduct. One possibility is not immediate personal financial liability, but structured personal accountability review, where a court, tribunal, ombudsman, or independent reviewer finds serious claimant-specific administrative illegality. The institution could be required to conduct a responsibility mapping exercise. This would identify who created the harmful input, who adopted it, who operationalized it, who reviewed it, who failed to correct it, and who defended it after contrary evidence emerged. The result need not always be punishment. It could be training, record correction, apology, policy change, referral to a professional regulator, or in serious cases personal costs or disciplinary action. AI could assist here, but only as an evidential and analytic tool. It could map chronology, inconsistency, repetition, and causal contribution. It should not decide guilt. The deeper point is that the state should not be allowed to dissolve human responsibility into institutional fog. The research questions are: should public law develop an intermediate doctrine of personal accountability review for serious administrative harm? Can responsibility be mapped without creating a chilling effect on legitimate public administration? Should public lawyers who defend unlawful administrative conduct after its defects become apparent face stronger professional or costs-based accountability? How can the law distinguish honest error, institutional negligence, reckless indifference, and deliberate misuse of power? The victim of peace is not a demand that every administrative mistake become a constitutional drama. It is a demand that public law takes seriously a particular kind of harm, severe claimant-specific life damage caused by peacetime state machinery, especially where the state simultaneously imposes operational consequences and denies procedural accountability. The core pathology can be expressed simply: the state must not be permitted to treat a person as a security object for operational purposes and as a procedural non-person for accountability purposes. This principle generates a research agenda rather than a finished doctrine. Public law must ask whether standing should follow operational effect. It must ask whether serious administrative illegality should produce compensation or other forms of repair. It must ask whether the taxpayer paradox makes ordinary damages conceptually incomplete. It must ask whether institutional liability without personal accountability is sufficient. It must ask whether artificial intelligence can help diagnose state defects rather than merely automate state power. In the age of geopolitical tension, liberal democracies rightly speak of the duty to support victims of war. But the same legal culture must also confront the casualties of its own peaceful machinery. The victim of peace stands at the edge of current doctrine, harmed by the state, yet not always recognized as a victim, targeted in practice, yet denied standing in principle, damaged in life, yet offered only the narrow language of legality. The task for future public law is not only to ask whether the state acted unlawfully, it is to ask what happens to the person after the state has acted, defended itself, paid if it must, and moved on. If public law cannot answer that question, then it does not yet fully understand the harm it is supposed to control. Originally published at linkedin.com.